immigration news, Child Status Protection Act. It's complicated, but listen up. A recent policy change on March 2nd resulting from litigation will benefit many children who would otherwise be aging out of their parents' green card applications. The Child Status Protection Act, CSPA, provides direction on whether to count a child as a derivative of a principal applicant for a green card. For Child Status Protection Act purposes, a derivative is somebody who is under the age of 21. An individual who is 21 or older is no longer eligible to qualify for a green card concurrently with a parent and must be independently sponsored by that parent, which results in significant delays. And there was a litigation in NACA versus USCIS argued before the U.S. Court of Appeals for the Ninth Circuit. It challenged USCIS's conclusion that for purposes of Child Status Protection Act analysis, a child's age was locked in only when the underlying priority date was current under the second of its two visa bulletin charts, the final action date, which is the date in which somebody can actually get a green card. The plaintiffs in the lawsuit argued that USCIS should use the dates for filing chart. That's the dates in which you can file an adjustment of status application. That's the dates in which the National Visa Center will complete processing your case at the National Visa Center, depending on whether you're filing the adjustment or the NVC. And that typically allows a green card application to be filed earlier. Now, this change is particularly significant for individuals from countries such as China and India, but it's significant for every country because almost on every country worldwide, the dates for filing are a lot closer and come up a lot faster than final action dates. And if in the calculation for Child Status Protection Act, your child is under 21 on the more liberal date, which is the dates for filing, that child's age is locked in for life on your case and doesn't age out even if they're 24, 25, 26, 27, 28. It's a complicated formula. So you could always call me and I can calculate it live because I'm good at math, or so I say. But it's good news for a lot of children who are aging out. Under the new interpretation, minor applicants will rely on the earlier chart for purposes of locking in their status as derivatives. Last week, USCIS has codified their rules for laid-off workers on non-immigrant visas. When non-immigrant visa workers are laid off, whether you're on an H, an E, an L, an O, a P, they may not be aware of their options, and many, in some instances, wrongly assume that they have no option but to leave the country within 60 days. So when a non-immigrant worker's employment is terminated, either voluntarily or involuntarily, you get fired, you quit, whatever it may be, they can typically take one of the following actions to remain in a period of authorized stay in the United States. They can file an application for a change of non-immigrant status. They can file an application for adjustment of status, or they can be the beneficiary of a non-frivolous petition to change employers. If one of these actions previous to 2016, you had no time, you didn't even have an hour to do it once you got laid off, you became illegal, undocumented. In 2016, they changed the law to say there's a 60-day grace period, and now USCIS has codified that law and made it completely clear to everybody that anyone who gets laid off, anybody who gets fired on a non-immigrant visa has 60 days to figure it out. So as long as you file an application for a change of non-immigrant status, file an application for adjustment of status, or the beneficiary of a non-frivolous petition to change employers within the 60-day grace period, you're still in legal status. The non-immigrant's period authorized stay in the United States, however, cannot exceed 60 days. So even if they lose their previous non-immigrant status, if the worker takes no action within this grace period, they and their dependents may have to depart the United States within 60 days or remain in the United States undocumented. Non-immigrant status is typically based on approved Form I-129, petition for a non-immigrant worker, or after admission, a subsequently approved Form I-539, which is the application to change non-immigrant status. Typically, a period of authorized stay includes the period when a timely filed non-frivolous petition or application requesting an extension of stay or change of status is pending with USCIS. Now, regulations have been codified, and they now permit a discretionary grace period, which allows workers in E's, H's, L's, O's, TN status to be considered as having maintained status in that same classification after they have been fired, after they have quit for up to 60 consecutive calendar days or until the end of the authorized non-immigrant validity period. The 60-day grace period is important. Before a regulatory change in 2016, there was no grace period, as I said, for a terminated non-immigrant worker. If you lost your job, you had to leave immediately. The maximum 60-day grace period provides time for non-immigrant workers to maintain their non-immigrant status. Alternatively, the 60-day grace period provides time for the worker to request a change of status, which allows the worker to continue their job search from within the United States. It also provides time for certain spouses of non-immigrant workers to continue working if they have an authorized employment document, a work permit. Within the grace period, eligible H-1B non-immigrant workers may also begin employment again as soon as they find a new employer and that new employer files an H-1B petition rather than waiting for that new petition to be even approved. A worker filing for employment in another classification, unfortunately, would have to begin employment only once the new petition is approved, but given the availability of premium processing, the wait for petition approval can be less than 15 days. The maximum 60-day grace period starts the day after termination of employment. USCIS will determine whether the grace period applies to your case during the adjudication of a subsequent extension of stay. And the grace period may apply to voluntary and involuntary cessation of employment. Basically, you're fired or quit, doesn't matter. But working during that grace period is prohibited. You would be working undocumented. But you have that 60-day grace period where you are still in authorized stay, can't legally work until you find a new sponsor, but then you can extend your stay. So typically, somebody gets fired, you're now given 60 days to find a new employer to file a new application. And on March 28th, USCIS announced it has completed the annual H-1B selection process, which is the lottery, the H-1B lottery for fiscal year 2024, with early reports indicating a record number of registrations submitted. Each year it becomes increasingly difficult to obtain one of the 85,000 H-1B visas allotted under the congressionally mandated quota, or known as the cap. In light of the news, employers and foreign national employees are now reviewing their contingency plans for those whose registrations were not selected. Employers must understand the duration and limitations of their employees' current visa status and evaluate potential opportunities to retain these talented individuals. For instance, some employees may be able to remain in the United States on their current visa to retry the H-1B lottery next year. Others may be eligible to change to another limited type of visa, such as a TN, an E, an O, an E1, an E2, or an E3, an O1, or possibly an L1, if they can meet the specific eligibility requirements for those categories. Others may be able to remain in the United States and even apply for employment authorization through a dependent visa of a spouse. While the limit on H-1B visas is meant to protect U.S. workers, the unanticipated consequence is work leaving the United States. When companies are unable to hire enough skilled workers in the United States, they will offshore these workers. They will relocate these workers abroad, giving countries such as India, China, and even Canada a competitive advantage over the United States because their tech workers and skilled workers are working outside of the U.S. And when companies offshore work abroad, in addition to decreasing the number of foreign nationals working in the United States, they may also find negative unintended outcomes. For instance, if certain processes are no longer handled in the U.S., companies may be required to reduce their number of U.S. workers as well. The effect of lost foreign national workers also negatively affects the U.S. economy as consumers, income, taxes all disappear. The recent study by Professor Rebecca Diamond of Stanford and her colleagues at Stanford and Stanford Graduate School of Business, Harvard Business School, and the University of California, Berkeley's Haas School of Business directly measured the output of patents from foreign-born inventors living in the United States. Their conclusion? No surprise. The average immigrant is substantially more productive than the average U.S.-born inventor. The researchers started with an understanding of how Social Security numbers work. Their first numbers contain the first year of their birth. In their database, they identified 300 million adults who had lived in the country between 1990 and 2016. and then used Social Security numbers to identify those who had immigrated after the age 19. Using names and address history, the researchers matched individuals in their database to those listed as inventors with the United States Patent and Trademark Office. Their findings show that immigrants generate patents across a broad swath of sectors, including computers, electronics, chemicals, and medicine. They also discovered that while all inventors reach peak productivity in their late 30s and early 40s, immigrants decline from that peak at a slower rate than US-born inventors over the rest of their careers. Some of the trend can be explained by self-selection, since the type of people who would likely migrate to the United States on high-skilled visas are likely to be very successful. Another factor is the positive effect of diversity. Collaboration with inventors in other countries and use of foreign technologies in their patented products seems to yield productivity. Whatever the causes, the authors say the policy implication is very clear. The U.S. has done an amazing job of attracting the best and brightest immigrants. Any policy that would revamp the visa process might want to consider how big a deal immigrants are in our innovation output. And this definitely holds true for Alina Kravchenko, who we had on our show, who had appeared on Shark Tank and got a deal with Kevin O'Leary and Lori Greiner for her invention, the Swipe and Snap. And she has already created 7 inventions and 7 utility patents. We had her previously on our show. U.S. Citizenship and Immigration Services has started to staff up a new virtual service center dedicated to only processing requests for humanitarian immigration relief, including visas for victims of crimes and domestic violence. In an exclusive interview, USCIS Director Jadoo described the additional service center as an important milestone and part of the agency's effort to reduce wait times for visas and other benefits. It will be the agency's 6th service center and first all-virtual service center. Everybody working at this service center will be working from home. Jadoo said, "One of my biggest visions for USCIS is to ensure that the backlog, this unprecedented backlog, is something that, by the time I depart the agency, is well on its way to recovery. The backlog has stopped growing. It's starting to pare down. My goal is to continue that slide downward." According to USCIS, this newest service center, which is currently operating on a hybrid model, but will eventually shift to all remote work, will begin its next round of hiring on this Friday. The agency aims to have the new service center fully staffed by the end of September 2024. It adds to existing service centers in California, Nebraska, Virginia, Texas, and Vermont. Although the center is virtual, it will accept both paper and electronic applications. It will focus on processing 4 types of requests for humanitarian relief: requests for status for crime victims under the U visa program and for domestic abuse survivors under the VAWA, requests for refugees to bring over their relatives from abroad, and requests by certain undocumented immigrants to waive their unlawful presence and become permanent residents. I know firsthand VAWA cases are taking over 3 years. 601A unlawful presence waivers are taking over a year. U visas are taking 6-7 years to get approved. So this is well overdue. Jadoo said these requests were selected because of their long processing times, just like I said. Immigrant advocates said the additional service center and staff could have sweeping impacts for abuse survivors awaiting immigration relief. Leslie Orloff, director of the National Immigrant Women's Advocacy Project at American University Washington College of Law, said that faster processing will allow abuse survivors to qualify for work authorization sooner, which for many could allow them to move out of their abusers' homes. The U.S. Justice Department is going on a hiring spree for immigration judges in hopes of easing their case backlogs as well. In its budget proposal for the fiscal year 2024 that starts on October 1st, the department is seeking $1.46 billion for the Executive Office for Immigration Review, basically immigration judges. Attorney General Merrick Garland said in a written testimony before a Senate Appropriations Subcommittee that the request represents an increase of nearly 70% in funding and will enable the agency to hire 965 new judicial staff, including 150 new immigration judges. Garland said they would be placed in areas of the highest number of cases. There are currently about 600 immigration judges in the country, more than double from just a few years ago, handling more than 2 million cases. In addition to hiring more judges for immigration courts, Garland said the Justice Department plans to expand virtual hearings at the U.S.-Mexico border as part of a backlog reduction initiative. Last year, the number of immigration removal cases topped more than 2 million people. 2 million people in removal, up from 344,000 a decade ago. 2013, 344,000 people in removal. 2022, 2023, on track for more than 2 million. Democratic Senator Jean Sheehan, chairwoman of the Appropriations Subcommittee, said it suggests that may not be the answer that we were hoping for. Sheehan said the ultimate way to ease the backlog is not more judges, it's through comprehensive immigration reform, a goal that we've been waiting for last comprehensive immigration reform was 86. So 3 generations, 60 years, 50 years, was 84, 04, 40 years. We're going on 3 generations now. President Biden is proposing increased spending to strengthen border security. In his proposed 2024 budget, the president would allocate nearly $25 billion to U.S. Customs and Border Protection and Immigration and Customs Enforcement. It's a nearly $800 million increase over the 2023 enacted level. In recent months, Biden has announced new proposals to mitigate and control direct migration to the United States-Mexico border, such as a migrant sponsorship program for people coming from Venezuela, Nicaragua, Haiti, and Cuba, and a proposed policy that would limit access to asylum for migrants if they fail to apply for protections granted by another country before reaching the United States. Breaking down the proposed $25 billion budget, CBP would be able to hire an additional 350 Border Patrol agents. $535 million would be allocated for border technology. $40 million would be used to combat fentanyl trafficking. Funds necessary to hire an additional 460 processing assistants at Customs and Border Patrol, and funds for asylum processing. Biden is proposing $865 million for USCIS. The proposed funds would go to 1, processing asylum caseloads and reducing their backlog. 2, reducing the request backlog of immigration benefits, such as work permits, travel documentation, and adjustment of status backlogs. Support the Citizenship and Integration Grant Program and improve refugee processing. And President Biden is also proposing a new $4.7 billion contingency fund to help the Department of Homeland Security respond to surges of immigrants at the U.S.-Mexico border. According to Biden's budget proposal, the fund would receive appropriations incrementally each fiscal year and above the base appropriation as encounters on the southern border reach pre-identified levels. The Department of Homeland Security would only use the funds for surge-related functions, and Biden is also finally proposing $7.3 billion to the Office of Refugee Resettlement to help rebuild the refugee resettlement infrastructure. The Biden administration has a goal of resettling 125,000 refugees in 2024. The administration has struggled to meet that goal after services were slashed under the Trump administration. Last week, we discussed legislation in the Texas Senate, which, if passed, will make undocumented entry into Texas a state crime, with first-time offenders facing a year in prison, second-time offenders facing 2, and offenders with a prior felony conviction facing life behind bars. Companion legislation to this, also in the Texas Senate, is the proposal House Bill 20. If House Bill 20 passes, Texas will field a new unit under its Department of Public Safety to track down, arrest, and deport undocumented people. Stationed at the border, the unit will be run by a chief serving at the pleasure of the governor, who will oversee a mix of locally recruited law enforcement and ordinary citizens without a felony conviction. It's the only requirement to be part of this new force is don't have a felony. These unit members will have immunity from criminal prosecution and lawsuits in pursuing their mission to arrest, detain, deter individuals crossing the border illegally, including with the use of non-deadly force. They will also use force to repel, arrest, and detain known transnational cartel operatives in the border region. Private citizens will be given arrest powers if they are trained and specifically authorized by the governor. The new unit will exist until 2030, at which point Texas lawmakers will decide on its reauthorization. Republicans have called the bill the Border Protection Unit Act. Texas Democrats have dubbed the proposal vigilante death squads. Victoria Neve Criado, the Democratic chair of Mexican American Legislative Caucus, said in a statement, "This dangerous, radical, and unconstitutional proposal, which empowers border vigilantes to hunt migrants and racially profile Latinos, is going to result in the death of many, many innocent people." By seeking to legalize state-run deportation squads, Texas Republicans have created a dilemma for their opponents: accept the existence of the new border unit until at least 2030, or risk challenging the law with a conservative Supreme Court, with 3 judges appointed by Donald Trump. The last thing Democrats want is for the Supreme Court to say this is legal. Eric Jamino, an assistant professor of criminology and justice studies at California State University, Northridge, grew up in the Rio Grande Valley, South Texas. Was also a police officer there for 8 years. And now researches the way border policing intersects border life. Said the Republicans know that this law is going to be unconstitutional, that's bound to get challenged in the courts, and that's why they're purposely doing it. If the gambit is successful, it will change the complexity of immigration enforcement on the border for the entire Southwest region. Here in New York City on March 28th, a council member honored immigrant women are making a difference beyond the Bronx community. Council member Marjorie Velasquez says she wanted to recognize 3 women because the contributions of immigrants are often overlooked. Dr. Camila Tapoulis, Diana Hernandez, and Rosemary Ordonez Jenkins all received proclamations for their work. Tapoulis is the executive director of the Morris Park Business Improvement District. Ordonez Jenkins runs the immigration nonprofit Garifuna Coalition. And Hernandez Cruz is a street vendor who went viral in 2021 when a fruit stand was shut down by city workers. Other women trailblazers spoke at the event, including Letitia James, the first Black woman to be elected Attorney General in the state of New York, and Darcel Clark, who was the first Black woman to serve as the Bronx District Attorney. The honorees said women are often the invisible forces that keep families, households, and communities together. Velasquez said she hoped highlighting the women inspires the next generation of young women. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.